This is file 26-22634-FH, People of the State of Michigan versus Lucas James McCabe. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. We're just going to have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good morning, Your Honor. Rhonda Underwood from Mr. McCabe this morning.
All right, where do we stand with Mr. McCabe's case today?
Thank you, Your Honor. Mr. McCabe is doing very well with his payments. I've spoken with Ms. Brenner, and we would request at this time a 90-day adjournment for another pretrial, Your Honor, and I would be happy to do the stip to adjourn with Ms. Brenner's permission.
That's accurate, Your Honor. This is our first pretrial, and he's making headway so far, so I'd like to see how he continues to do. I don't have any objection to her preparing that and signing my name.
Okay, I will adjourn this then to September 16th at 8:15 a.m.
Thank you very much, Your Honor.
Thank you.
So Mr. McCabe, your next date is September 16th at 8:15 a.m. You'll log in using all the same Zoom information that you used today.
Okay, thank you.
Thank you. All right, I have someone here on a Samsung device. I'm going to send you a request to start your video. Okay, and I'm going to send a request to unmute your device. And you are Mr. Cherry, correct?
Sir.
Ms. Underwood, do you need to speak to Mr. Cherry?
No, I do not, Your Honor. Thank you.
Okay.
Your Honor,
Let me call the case first, Ron.
thank you.
This is file 22-20683-FH, People of the State of Michigan versus Paul Edward Cherry. We are here today for a pretrial on a probation violation. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Cherry this morning, Your Honor. Thank you.
And sir, you are Paul Edward Cherry, correct?
Yes, sir.
All right, Ms. Underwood, where do we stand with Mr. Cherry's situation?
The bankruptcy has been refiled, Your Honor, and Mr. Cherry, I believe, is waiting for a date from them, and he has not received it yet. I believe that he has requested, and he's still waiting, Your Honor. I would ask for, I believe, a 30-day adjournment to see that there's movement on that.
I will adjourn this to July 15th at 8:15 a.m. Mr. Cherry, you'll log in using all the same Zoom information that you used to log in today.
Yes, sir. Thank you.
You're all set and go ahead and log out. Okay, could you call for Patrick Skinner?
Nice. County Judges. Could we get Patrick Skinner, Judge, please? Thank you. Bye.
How do I get out of this?
Well, that was fast.
1 second, Mr. Chair. I can do that from my side. Mr. Bayonetta, what cases are you covering today?
Your Honor, I think I'm the only prosecutor from our office that you'll have. So every case that's not the AG's, I think will be mine.
Okay. Mr. Fry, do you need to speak to, you have Mr. Browder, is that right? No, that's Mr. Malaros. I'm sorry. Who are you here for, Mr. Fry?
I have Mr. Anthony Watson Clark.
Okay. And Ms. Underwood, do you need to speak to Mr. Madrid?
I don't believe I have Mr. Madrid this morning, Your Honor. Believe that's mine.
Mr. Fry, are you ready to proceed with Mr. Watson Clark, or do you need to talk to him?
I'm ready to proceed, Your Honor.
Mr. Watson Clark, if you're there, I've sent you a request to start your video. All right. This is file 25-22230-FH, People versus Anthony Wayne Watson Clark. We are here today for a pretrial conference in this case, and I have the attorneys place their appearance on the record, beginning with Mr. Bayonetta.
Alex Bayonetta for the people.
Brian Fry for the defendant, Anthony Watson Clark.
And sir, you are Anthony Wayne Watson Clark. Your device is mute. Send your request to unmute your device, Mr. Watson Clark. Mr. Watson Clark has dropped out of the meeting. Based on what I could see from his video footage, it looks like he's in an area with a poor internet connection. So we'll see if we get him back. Mr. Watson Clark, can you hear me?
Yes, I can, sir. Can you hear me?
Okay. Mr. Watson Clark, I'm going to stop your video and hope that will improve the quality of your audio. If you give me just a moment.
Okay, thank you.
And you are Anthony Wayne Watson Clark, correct?
Yes, Your Honor.
Okay. Mr. Fry, where do we stand with Mr. Watson Clark's case today?
We would be asking for another adjournment, Your Honor. He is still in the middle of completing diversion. He's whittling down the payments as part of that program. Looks like he's working right now from his video, what I could see in the background. He's making some progress. He just needs some more time. So we can set it out. I don't know. He probably needs a few months or so. Thank you.
Okay, Mr. Bayonetta, anything you would like to address?
Just, Your Honor, the defendant had it was a few $1,000s in between the diversion fee and the restitution. He's made payments. I think he's about halfway done at this point. So I have no objection to an adjournment however far out the court wants to go. He's been making payments every month since really since the spring started. It was a little slower start because he works construction, but since the season has started, he's been faithfully making payments.
Let's adjourn this then to September 2nd at 8:15 a.m.
Okay, thank you.
Mr. Watson Clark, you said something, but I was unable to understand it due to the audio quality. Did you hear that date, September 2nd?
I did, Your Honor.
Okay, so it's 8:15 and you'll log in using all the same Zoom information you used today.
Sounds good.
Mr. Fry, would you prepare that stipulation in order, please?
Yes, I can prepare that. Mr. Bayonetto, could I sign your name to that with permission?
Yes, please.
Thank you.
All right, Mr. Watson Clark, you're all set for today. You can go ahead and log out.
All right, thank you.
Thank you, Your Honor.
Thank you. All right, we are on the record in file 24-22029-FH and 24-22030-FH, People versus Patrick Lee Skinner. We are here today for arraignment on a bench warrant, and we are proceeding today by video conference. So you are Patrick Lee Skinner?
Yes, sir.
Mr. Skinner, have you received copies of the warrants in these files?
Yeah.
The warrants in each file, there's one in each file, they allege the same thing. They allege that you violated your article of probation by failing to enter into and complete the residential program through the Veterans Administration Hospital in Valley, Michigan, that you left the program on February 25, 2026. You had previously, these are warrants for probation violations. I apologize, not for bond violations. You had previously in file 24-22029-FH pled guilty to larceny in a building. The maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine. In file 24-220-FH, you had pled guilty to possession of methamphetamine, and the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine. Do you understand that, Mr. Skinner?
Yes, Judge.
You are entitled to be represented by an attorney today and in any other proceedings we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Would you like to be represented by an attorney?
Yes, Judge.
Do you have the ability to pay for your own attorney?
No.
All right, I will appoint the public defender's office to represent you. I'll place you in a breakout session with Ms. Underwood from the public defender's office right now.
Thank you, Your Honor. I'm not sure
Okay.
what happened back.
I apologize, Ms. Underwood. I clicked the wrong button, so let me set that up again. Okay, we have Mr. Skinner and Ms. Underwood back from breakout session. I will also let you know at this point, Mr. Skinner, Ms. Underwood, that Mr. Skinner also had a bench warrant for failure to appear at a violation of probation pretrial on April 15, 2026. The maximum possible penalty for that is 93 days in jail or up to $7,500 in fines. Mr. Skinner also had a pending probation violation, which he's already been arraigned on for failing to report on November 5, 2025 or any time thereafter, failing to submit to drug screens on October 15, 17, 20, 23, 28, and 31 of 2025, failing to obtain a substance abuse assessment as instructed, and by violating criminal law by using methamphetamine on December 3, 2025, November 19, 2025, 12, 2025, and October 15, 2025. So those are all the things we are here on today. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Mr. Skinner this morning, Your Honor. Thank you.
Do you know how Mr. Skinner wants to proceed today?
I would ask the court to enter a not guilty plea for Mr. Skinner, Your Honor. I believe Mr. Skinner had some medical issues that necessitated attention, Your Honor, but we want to go through that. Mr. Skinner, Your Honor, I would say has stabilized and has leased an apartment, which he would very much like to keep. I realize the court's position, but I would ask if the court would set this for next week and consider a bond with any, or a PR bond with any tether or reporting requirements the court is comfortable with.
Judge, obviously our position is no bond at this time, given his opportunities to complete treatment, and he left, did not contact our office. Thank you.
I am not here next week, so the next available date I have is June 24th. So I will set this for June 24th at 8:15 a.m. Not inclined at this point to make any modifications to bonds in this case for reasons that the court has identified on the record in previous hearings. I'll just highlight them here to say that Mr. Skinner has been given just about every possible opportunity to engage in treatment. He has absconded numerous times. He has failed to appear numerous times, and the court went to great lengths in this most recent situation to get Mr. Skinner to the VA program in Battle Creek, after which he left apparently after 3 days. So I just don't have any confidence that Mr. Skinner would do anything that he claims he says he would do on a PR bond. There's no, it would be foolish for me to issue a PR bond to Mr. Skinner at this point based on the history that has occurred. So not going to change the bonds.
Thank you, Your Honor.
Judge, I left because I have to have surgery still.
I'm sorry?
I left because I had to have surgery still on my gallbladder. That I still haven't been able to get that.
I'm not going to argue, Mr. Skinner.
I'm not trying to argue with the judge. I'm not.
You can let the officer with you know that you're done with court for today. Okay, Ms. Underwood, you need to speak to Stephen Johnson.
Yes, please, Your Honor.
All right, Mr. Johnson, I'm going to put you in a breakout session with Ms. Underwood.
Yes, Your Honor. Thank you.
Okay, can you call for Crystal Clare?
Could we have Crystal clear judge, please? Thank you. Bye.
The gentleman that just logged in on the Samsung device, can you tell me your name?
My name is Zachary Hearn.
Okay, 1 second.
Thank you.
Okay, I'm going to put you back in the waiting room until your attorney is ready to speak to you.
Yes, sir. Thank you.
Okay, this is file 24-21757-FH, People versus Stephen Jermaine Johnson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Johnson this morning. Thank you.
And sir, you are Stephen Jermaine Johnson?
Yes, Stephen Jermaine Johnson, Your Honor.
Okay, Ms. Underwood, where do we stand with Mr. Johnson today?
Your Honor, I know there's been a problem getting the income withholding started. Mr. Johnson has personally taken that down to HR. He's explained the situation to them. They have the paperwork. They're going to implement it, Your Honor, now. And he's also went down to the front of the court and made sure they had his information. Unfortunately, payments actually haven't started yet. I know Ms. Brenner wants payments and the probation department. Mr. Johnson wants to pay. I would ask their patience just for a single, maybe 30-day adjournment to get these started. Thank you very much.
Your Honor, when we were here last on May 27th, the defendant said he was getting paid that Friday, and that if it wasn't taken out by income withholding order, he was going to bring the payment down on his own. That didn't happen. Nothing's been paid.
Court's been dealing with this for 6 months now, so I can't understand what the holdup is. So I'll just set it for a hearing, and we can make a determination. If he can start making payments before the hearing, I'll be willing to consider, but I can't at this point do anything in the absence of payments starting to happen. So
thank you, Your Honor.
Ms. Clark, can we have a 1-hour hearing date for a probation violation?
Yes. Tuesday, June 23rd at 3 o'clock.
Can we do another day besides Tuesday? That's our report day.
Friday, June 26th at 1:30.
And Your Honor, I'm assuming I can still do that via Zoom. Is that okay?
Yeah, Zoom attendance is okay for that as far as I'm concerned.
Okay, thank you.
All right, so June 26th at 1:30 p.m. Is there anything else we need to address at this point?
I don't believe so, Your Honor.
I don't think so either. Thank you, Judge.
All right, see everyone back on June 26th at 1:30 p.m.
Thank you.
Okay, Mr. Amadeo, we've called for Ms. Claire. She was apparently picked up on a bond violation last night. So as soon as we have her, I assume you'll want to speak to her?
No, Judge, I want to go visit her. If I understand there's a new charge coming, I could actually waive her appearance. I spoke to the prosecutor. We're just going to ask for an adjournment of a few weeks. I'm going to see if I need to take over the other file for her. But I don't want to take up your court's time. I will go visit her the next 2 days myself.
Okay, let me call those cases then. So this file 26-22649-FH and 26-22650-FH, People of the State of Michigan versus Crystal Ann Claire. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Alex Brianetto for the people.
Good morning, Your Honor. William Amadeo, P76194. On behalf of Crystal Claire, I consent and appreciate the Zoom. I will waive her appearance for this pretrial.
Okay, and as I said, it's my understanding she was picked up on a bond violation last night and is at the Lenawee County Jail. We've called for her, but they haven't logged her in yet. Mr. Amadeo, you, I think, just said that you think she has some new charges coming.
I was told from her son's probation officer last night, because I have his case on the NA file, that there was a new district court case. I believe it's a misdemeanor, and I believe we'll have a bond violation in this matter. I'd like to get my head around that. I'm going to ask for just a 2-week adjournment right now, Judge. I will get to the jail to see her in the next 48 hours, determine if I'm going to be on that file or what I need to do, and take it from there. If it is just a bond violation, I'll probably just have her admit responsibility, ask for release. But right now, I just want to find out. It is my understanding there's a new case, Your Honor. So I don't want to hold your court up with that.
Okay. Mr. Banetto, is there anything that you would like to address?
No, Your Honor.
All right, so I'll adjourn this to June 24th during the pretrial. And I mean, I guess although I've been told that she's there at the jail on a bond violation, and I've received a document that tells me what the bond conditions are. I don't have any formal charging document for a bond violation to arraign her on at this point. So I suppose at some point, if I get that, I will
talk to you sometime about my
yeah.
trial.
So
Judge, I actually have a
otherwise,
copy of that. As part of her bond conditions, she's not to leave her residence when they're.
yeah, I know there's a document that says what the bond conditions are, but I need to have, someone has to file a complaint charging the bond violation. So if I get that, we'll set up an arraignment. Otherwise, we'll be back on June 24th at 8:15 for the pretrial in all of these cases.
And I'll prepare a stip, Your Honor. Alex, can I just sign your name with permission? And when I go to the jail, I'll update everybody what I can find out.
Yes, please. Thank you.
Thank you.
All right.
Okay.
I think we're all set on these cases then.
Thank you, Judge. Take care.
Thank you. Ms. Underwood, you need to speak to Mr. Herr.
Just for a second, Your Honor.
Okay, Mr. Herr, I'm going to put you in a breakout session with Ms. Underwood.
Yes, sir. Thank you.
Okay, if someone signed in on a device labeled Moto G 2025, I'm sending you a request to start your video. And now I'm sending you a request to unmute your device. Can you tell me your name, please?
Jake Junior Vargas.
Okay. 1 second. And Mr. Sinclair, are you there?
Yes, sir, I'm here.
Okay, and are you ready to proceed with Mr. Vargas?
Yes, sir, I'm ready.
Okay, this is file 25-22317-FH and 25-22318-FH, People of the State of Michigan versus Jake Junior Vargas. We are here today for a final pretrial conference in both of those cases. And we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Yes, sir, and good morning, Judge. I'm Christopher Sinclair, 80512, appearing with and on behalf of Mr. Vargas, who appears on the screen.
And sir, you are Jake Junior Vargas, correct?
Yes.
Okay, Mr. Sinclair, where do we stand with Mr. Vargas's cases today?
Yes, sir. I've had an opportunity to speak with the people on this matter, and we have come to a resolution. The court should be in possession of a signed plea form that includes a no contest plea as charged to count 1 in case 2522317FH. The agreement is to dismiss count number 2 in case 2522317FH and to dismiss case 2522318FH in its entirety with the sentence agreement to 84 months as a cap, MDOC, or the bottom of the guidelines if the sentencing guidelines are calculated lower at the time of sentencing. And Mr. Vargas is prepared to accept that offer today.
Okay, Mr. Bayoneto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
I will also note for the record, I've been given a copy of a signed advice of rights form from Mr. Vargas and placing that in the file. Mr. Vargas, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Jake Junior Vargas, correct?
Yes, sir.
Mr. Vargas, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1 and file 25-22317-FH?
Yes, sir.
Delivery or manufacture of cocaine of 450 to 999 grams.
Yes, sir.
I'm sorry, Judge, it was a no contest. I
Oh, I'm
apologize.
sorry. I'm sorry. So your intention to plead no contest to that, Mr. Vargas?
Yes, sir, it is.
Are you satisfied with Mr. Sinclair in the advice that he's given you?
Yes, sir, I am.
Do you understand that the maximum possible penalty for that offense is up to 30 years in prison and or a $500,000 fine?
Yes, sir, I do.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. Bandit?
That's correct, Your Honor.
Mr. Sinclair?
Yes, sir.
Is that also your understanding, Mr. Vargas?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means, I'm sorry, if a no contest plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Vargas, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, sir, I do.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about October 17, 2024, in the city of Adrian, county of Lenawee, they did commit the offense of delivery or manufacture of cocaine of 450 to 999 grams?
No contest.
No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Vargas to plead no contest today?
No, Your Honor.
No, Judge.
Mr. Vargas, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here this morning?
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead no contest today?
Yes, sir.
Okay, how are we establishing the factual basis then?
I can put the factual basis on, Your Honor.
Okay.
Your Honor, had this matter proceeded to trial, the people would have proven beyond a reasonable doubt that on or about September 17th of 2024, in the city of Adrian, county of Lenawee, the defendant was, I apologize, Your Honor, strike that. The Michigan State Police Rhino detectives executed a search warrant at 603 South Center Street. Your Honor, that warrant was procured after the Rhino detectives had utilized various surveillance of the residents, observing various conduct that they deemed was consistent with trafficking in narcotics. Upon entry into the residence, there were two individuals that were living in the residence. One was a Daniel Jaso, the other was Mr. Jake Vargas. Your Honor, upon entry into that residence, the detectives located a gallon bag full of a substance that was later confirmed to be a cocaine-based substance. The weight of that was 886.12 grams. Further, Your Honor, that was located at what the officers believed was a cook station with various things that would be utilized to make the cocaine base into what they believed was going to be crack cocaine. Your Honor, the defendant had multiple items of mail located directly underneath the substance that was determined to be cocaine. Mr. Vargas was not present at the time of the raid. However, given his close proximity, the close proximity of his items as well as his mail, it was determined that he was in possession of that cocaine and had been intending to deliver that amount, as it is significantly more than what would be considered for personal use. With those facts, Your Honor, I believe the factual basis would be satisfied for count one, delivery of slash manufacture of cocaine, 450 to 999 grams.
No objection, Judge.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. Bannon?
It has, Your Honor.
Mr. Sinclair?
Yes, sir.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Vargas has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 30th at 8:15 a.m.
And Judge, just in consideration of the fact that we anticipate a significant amount of incarceration in this matter based on the agreement, the defense is requesting a sentencing that may be 90 days from today in order to allow Mr. Vargas time to get his affairs in order in preparation to serve the anticipated sentence.
Hello?
Mr. Bannon?
I'll defer to the court's discretion on that matter, Your Honor.
All right,
Hello?
so June 30th. Mr. Hurd, just hang on a second, all right?
Ooh, yes, sir. Sorry, Your Honor.
June 30th is, I'm sorry, July 30th is, I think, a sufficient amount of time into the future for Mr. Vargas to prepare himself for the sentence that he has agreed to. I don't think an extended amount of time beyond that is necessary. So I'll leave it at July 30th at 8:15.
Is that on Zoom or in person?
Sorry?
On Zoom?
July 30th.
Is it on Zoom? Like,
Oh, I'm sorry. No, that will be in person.
So on the 30th, I actually have a matter in federal court at 10 o'clock. It'll be fine for Zoom, but in person, that would create a challenge.
How about July 31st?
That should be fine, Judge.
All right, so July 31st at 8:15 a.m. Okay, I am going to put Mr. Vargas, Mr. Sinclair, and Ms. Walsh, the probation officer, in a breakout session so that Ms. Walsh can collect your contact information, Mr. Vargas.
Thank you.
Yes, sir.
Mr. Malero, do you need to speak to Mr. Browder?
Where'd you go, Judge? No, I do not, Your Honor.
Okay. Let me call Mr. Herr's case first, and then we'll go to Mr. Browder. So this is file 26-22642-FH, People of the State of Michigan versus Zachary Dwayne Herr. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Banetto?
Alex Bayanetto for the people.
Ron Underwood for Mr. Herr, Your Honor.
And sir, you are Zachary Dwayne Herr. Your device is muted.
Yes, sir, I am, Your Honor.
Okay, Ms. Underwood, where do we stand with Mr. Herr's case today?
Thank you, Your Honor. I believe there has been a plea bargain offered and accepted, Your Honor, whereby Mr. Herr will plead guilty to count one, a two-year high court misdemeanor, I believe, resisting and obstructing, with no upfront jail. All the other counts will be dismissed, and Mr. Herr will be in the enhanced treatment court. And upon successful completion of that, Your Honor, the charge would be amended to an attempted resisting and obstructing, a one-year misdemeanor. And I believe that encompasses the plea, Your Honor.
Mr. Banetto, was that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right. Mr. Herr, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do, Your Honor.
And you are Zachary Dwayne Herr?
Yes, I am.
Mr. Herr, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, assaulting, resisting, or obstructing a police officer or first responder?
Yes, sir, Your Honor, I do.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a fine of $2,000?
Yes, sir, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, sir, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. Banetto?
That's correct, Your Honor.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Mr. Herr?
Yes, Your Honor.
Mr. Herr, if a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify at your trial if you want to testify. You have the right to be present at your trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. Do you understand, Mr. Hur, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor, I think I'm good. Yes, sir.
Do you understand that you're giving those rights up?
Yes, sir, Your Honor.
How do you wish to plead to the charge that on or about April 19, 2026 in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer or first responder?
Your Honor, I did resist, so I plead guilty.
Has anyone made any threats, promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter that plea?
Okay.
You understand that?
Yes, sir, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements to, other than the plea bargain, to induce Mr. Hur to plead guilty today?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Mr. Hur, other than as we've discussed it on the record today, has your attorney promised you a particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement for evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir, Your Honor.
Is it your own choice to plead guilty today?
Yes, sir, Your Honor.
Ms. Underwood, would you like to establish the factual basis?
Thank you, Your Honor. Mr. Hur, let me take you back to April 19th, 2026. Were you located in the city of Adrian, county of Lenawee, state of Michigan?
Yes, ma'am.
And at that time, did you come into contact with Officer Katie Morris, a officer from the City of Adrian Police Department?
No, it was a male officer.
Well, do you remember a female officer?
Yeah, that's the officer that I laid down on the ground for. Yes, ma'am.
Well, there was an officer that you, when the officers asked you to stop, they were investigating a situation with you, correct? They were investigating a situation with you, and they asked you to stop, and you ran from them, correct?
Yes, ma'am. I ran from the male officer. Yes, ma'am.
Okay. And you knew he was a police officer?
Yes, ma'am.
And he was in his uniform, correct?
Yes, ma'am.
And you knew he wanted to talk to you, and he told you to stop, right? And you ran.
Yes, ma'am.
I believe the facts have been established, Your Honor.
Okay, are we going to do count 2 then instead of count 1?
We
I
can
think that
switch
makes the
to
most
count
sense, Your
2.
Honor.
All right, so based on the factual record that's been established today, I think the appropriate plea would be count 2, which is just a separate count of assaulting, resisting, obstructing a police officer that involves a male officer, which is what Mr. Hurst testified to today. Has the court complied with MCR 6.302 B, C, and D, Mr. Banetto?
It has, Your Honor.
Is underway?
It is, Your Honor.
Okay, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Hur has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 30th at 8:15 a.m.
Okay, Your Honor.
Yes, sir, Your Honor.
How does the referral to enhanced treatment court affect a sentencing that would take place on the 30th?
Typically, I would do the sentencing, and after sentencing, the case would be transferred to the treatment court judge.
Thank you.
Mr. Hur, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir. Thank you, Your Honor.
Okay, I'm going to put you in a breakout session with Ms. Walsh from the probation department so that she can collect your contact information and let you know what you need to do next.
Yes, sir. Thank you, Your Honor.
Okay, Mr. Malero, you ready to proceed with Mr. Browder?
Yes, Your Honor.
Do you also have Louis Madrid? Is he your
I do.
case?
Yes,
Okay.
I do.
And are you going to need to speak to him?
Yeah, I could probably need to talk to him.
Let me have you do that first since we don't have our probation officer for a minute.
Okay.
Okay, Mr. Madrid, if you're there, I need you to start your video and unmute your device. Okay, Mr. Madrid, I'm going to put you in a breakout session with Mr. Malero.
All right, thank you.
Thank you, Judge.
Your Honor, while Mr. Malaro is speaking to him, I'm going to step out for just a second. I'll be right back.
Okay. And let's see, can you call for Wayne Parker?
Wayne Parker, the judge, please.
Good morning. Are you Crystal Clare?
Good morning, Your Honor.
Okay, Ms. Clare, we already spoke with your attorney and he asked that your hearing be adjourned to June 24th. So we've done that and he's gonna either come see you at the jail or Zoom with you at the jail.
Well, I have a question though. I came to jail yesterday for leaving my home on a PR bond thing. And I gotta leave my home to go to therapy and everything.
All right, you gotta stop. You gotta stop, Ms. Clare. You gotta stop. That's something you need to talk to your attorney about.
Can I talk to my attorney?
He's not here right now. He's gonna get in touch with you later today, I think.
So I have to stay here until later today? I mean, I'm not here on anything but leaving my home. And that's crazy.
You need to stop talking. Your attorney's gonna contact you at the jail. If it's appropriate for us to come back on the record later today, we'll do that.
Thank you.
Larry, thank you.
All right, bye.
This is file 26-22602-FH People versus Louis G. Madrid III. We are here today for a pretrial hearing. We are proceeding today by video conference. First, we have the attorneys place their appearance on the record, beginning with Mr. Banetto.
Alex Bayanetto for the people.
Salvatore Malero on behalf of Louis Madrid III.
And sir, you are Louis G. Madrid III.
Yes, I am.
Mr. Stand with Mr. Madrid's case today.
Your Honor, I would ask to adjourn the matter for about 30 days. Mr. Madrid will be needing to have new counsel assigned. And I think that would be an appropriate amount of time for new counsel to become familiar with the case. So that's basis for my request.
Okay, Mr. Banetto, anything we need to address from the people's side?
No, Your Honor.
All right, I will adjourn this then to July 15th at 8:15 a.m. Well, Mr. Madrid, your next date is July 15th at 8:15. You'll log in using all the same Zoom information that you used to log in today.
Okay, thank you, Your Honor.
Thank you. You can go ahead and log out.
Thank you, Judge.
Okay, and Mr. Malero, are you ready to proceed with Mr. Browder?
I am, Your Honor.
This is file 25-22414-FH, People versus Michael Deshawn Browder. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can have the attorneys place their appearance on the record, beginning with Mr. Banetto.
Alex Bayanetto for the people.
Salvatore Malero on behalf of Michael Browder.
And sir, you are Michael Deshawn Browder?
Yes, sir.
All right, Mr. Malero, where do we stand with Mr. Browder's case today?
Your Honor, similar to Mr. Madrid's situation, Mr. Browder is going to be needing to have new counsel assigned to his case. And so I'm asking to adjourn this matter. However, I would ask for a 60-day adjournment. His case is far more involved with respect to some aspects of the case. And I think 60 days would be appropriate for a new counsel to become familiar with those issues and to properly brief them if that's what they decide to do.
All right, Mr. Banetto, is there anything we need to address from the people's side?
No, Your Honor.
All right, I will adjourn this one then to August 19th at 8:15 a.m. So, Mr. Browder, your next date is August 19th at 8:15. You'll log in using all the same Zoom information that you used to log in today.
Yes, sir.
Okay.
Thank you, Your Honor. And Judge, as to both matters, I'll do the stipend orders.
Okay, thank you, Mr. Malero. I appreciate that.
Thank you, Judge. Have a good day.
Thank you. You too. Okay, this is file 18-45512-DP. Laura Jean Curtis versus Wayne David Parker II here today for arraignment on a bench warrant. We are proceeding today by video conference. Sir, you are Wayne David Parker II.
Yes, sir.
Mr. Parker, have you received a copy of your warrant?
Nope.
All right, we'll have a copy of the warrant sent over to you in a moment. I will let you know in the meantime that the warrant alleges that you failed to appear at a show cause hearing related to child support on June 1st, 2026. The underlying show cause for non-payment of child support indicates that you have a monthly child support charge of $223 per month, and that there is currently an arrearage in support payments in the amount of $8,989.58. Do you understand, Mr. Parker, that it is a crime to fail to pay child support to the best of your ability up to the amount ordered?
I do.
Do you understand that it's a crime to fail to appear in court when you've been ordered to appear?
I do.
Do you understand that if you were to plead guilty or be found guilty of either of those offenses, the court could sentence you to jail for up to 30 days?
I understand.
You are entitled to have a trial and can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You are entitled to have an attorney represent you today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes, sir.
Would you like to be represented by an attorney?
No, thank you.
You are entitled to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions while they're under oath. You also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes, sir.
You are not required to say anything at your trial. No one can hold that against you or say anything about you not testifying. Do you understand that?
Yes, sir.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that also?
Yes, sir.
Do you know how you want to plead to the charge that you failed to appear in court?
Not guilty.
Do you know how you want to plead to the charge that you failed to pay child support up to the best of your ability up to the amount ordered?
Not guilty.
All right, I'll enter not guilty pleas for you on both counts, and we will set a trial date for that. The next available date is June 23rd at 8:15 a.m. Just 1 second, Mr. Parker. All right, so your next date is June 23rd at 8:15 a.m. Bond on the bench warrant is $8,766. That was the amount of the arrears at the time it was issued. So, Mr. Parker, you can let the officer with you know that you're done with court for today.
Is there to ask a quick question?
Yeah.
Is my bond still gonna remain the same or no? Because I had some job set up, so I was just curious.
Well, what other jobs do you have set up?
The cleaning job in Tecumseh at 11, but I don't even know what time it is right now, honestly.
All right. Well, based on your failure to appear, I'm going to leave the bond where it's currently set.
All right.
All right. So you can let the officer with you know that you're done with court for today.
All right. Thank you.
Mr. Murphy, are you ready to proceed with Mr. Valdez?
Yes, Your Honor.
This is file 25-22482-FH, People versus Samuel Raul Valdez. We are here today for a pretrial conference in this case, and we are proceeding today partially in person and partially by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Bandetta.
Alex Bayoneto for the people.
Matthew Murphy appearing on behalf of Mr. Valdez.
And so you are Samuel Raul Valdez?
I am, Your Honor.
All right. Mr. Murphy, where do we stand with Mr. Valdez's case today?
Your Honor, I have Mr. Valdez screened, and he does qualify for minutes to, and I do want him to enter into the Veterans Court. As such, I guess I wasn't sure Mr. Bayoneto would offer for him to plead as charged or to an attempted CCW no contest. But either way, he wanted to enter a no contest plea, again, either to the CCW or attempted whatever Mr. Bayoneto was offering, and with an agreement for him to go into Veterans Court. My understanding would be that based upon successful completion, entrance and completion of Veterans Court, that the charge would be dismissed. So Mr. Valdez does want to do that today, if I was correct on all that.
I hadn't actually made an offer as to what I wanted him to enter a plea to. I guess, Judge, since you are the Veterans Court judge, if I offered him a plea to disturbing the peace today, would he still be eligible to remain in drug court or Veterans Court?
That would not impact his ability to be in Veterans Court.
So it was my intention to have him plead to something along the lines of that after discussions, multiple discussions with the officer and looking at the background situation in this case. We both felt that a plea to something like that was a little more appropriate. We just wanted to make sure we could get him into Veterans Treatment Court. So in the interest of wanting to get this done today, if the court is okay going forward with a plea to that, I'd be okay moving forward.
And obviously the defense will be fine with that.
Okay, I'm gonna need an amended information then.
Yes, Your Honor. If you just give me a few minutes, I'll get that in right now.
Sure. And I'm also gonna need an advice of rights form. We also have the report from the Center for Forensic Psychiatry, and we have not yet conducted a hearing on competency, so we need to do that.
Oh, I apologize.
Before we do anything else.
Apologize, Your Honor.
We lost Mr. Bayoneto to preparing the amended information, so as soon as we have him back.
I'm still here, Judge.
Okay. All right, so we do need to conduct a hearing on competency. The court has received a report from the Department of Health and Human Services Center for Forensic Psychiatry. Mr. Bayoneto, do you want any argument or further proof on the competency issue?
No, Your Honor, I'd ask that the court accept that into evidence at this time.
Okay. Mr. Murphy, does the defense have anything they would like to offer on the issue of competency?
No, Your Honor, we received said report as well, reviewed it. We would agree with the entrance of that into evidence in regards to this competency review.
I have received that report dated May 7, 2026 from the Department of Health and Human Services Center for Forensic Psychiatry, authored by Lisa Anaker, MD. I have reviewed that report. It does find that Mr. Valdez is competent to stand trial. This finding was made after a forensic examination of Mr. Valdez, and as indicated, does reflect that he is competent to stand trial. So the court will enter an order finding Mr. Valdez competent to stand trial in this case, and then we will proceed then with the plea as soon as that amended information is received. I also will print a advice of rights form for Mr. Valdez to review and sign.
Your Honor, I just sent that amended information over, so you should have it momentarily.
Okay, thank you.
Yeah, it's 6:10, right? Yeah. 6:10.
Okay, I do have that amended information now. And do have the signed advice of rights form from Mr. Valdez. Mr. Valdez, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do, Your Honor.
You are Samuel Raul Valdez?
I am.
Mr. Valdez, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 2, disturbing the peace?
It is, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 90 days in jail and or a $500 fine?
I do.
Are you satisfied with Mr. Murphy and the advice that he's given?
Yes, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record today. Is that correct, Mr. Banetto?
Correct,
That's
Your Honor.
correct.
Mr. Murphy?
That's correct, Your Honor. Wasn't asking.
Is that also your understanding, Mr. Valdez?
Yes.
If a no contest plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Valdez, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Do you understand that, Your Honor?
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, I don't, Your Honor.
Do you understand that you're giving those rights up?
I do.
How do you wish to plead to the charge that on or about September 19, 2025, in the city of Adrian, County of Lenawee, state of Michigan, you did commit the offense of disturbing the peace?
No, no contest, Your Honor.
Has anyone made any threats or promises to you to induce you to plead no contest to that charge? Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Valdez to plead no contest today?
No, Your Honor.
No, Your Honor.
Mr. Valdez, other than as we've talked about it here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I do understand that.
Is it your own choice to plead no contests today?
Yes, it is, Your Honor.
All right. And how are we establishing the factual basis?
Your Honor, I can place the factual basis on the record, and Mr. Bayonet would have no objection to that based upon a reading from the police report.
No objection.
Okay. So, Your Honor, the defense would stipulate and agree to the following facts that would be proven beyond a reasonable doubt at trial. And I'm reading from, or looking at the police report that was delivered from the prosecution of this matter, from the Adrian Police Department. I'm not sure what number it will be considered, but either way, on September 19th of 2025, we would agree and stipulate and agree that Mr. Valdez was in the city of Adrian, the county of Lenawee, state of Michigan, that about 8 o'clock at night or so on that date and time, that police had contact with Mr. Valdez based upon a call of Mr. Valdez, possibly engaging in some destruction of property. Upon the contact with the police, a search was done. Mr. Valdez indicated he did have a weapon. A search was conducted, and brass knuckles was found in his back pocket of his pants, concealed. We would agree that that would, quite frankly, that would be satisfy the factual basis for the as charged. Also, the behavior of the possible destroying of the police or of the property would satisfy the factual basis for the disturbing the peace, as obviously a member of the public was disturbed and called the police in regards to the matter. So we would agree that those would satisfy the factual, those facts would satisfy the factual basis.
All right, Mr. Bennett, are the people satisfied with that as a factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bennett?
It has, Your Honor.
Mr. Murphy?
It has, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here this morning. I will refer this matter to the district court probation office for a pre-sentence investigation. We will set sentencing for July 23rd at 8:15 a.m. Mr. Valdez, you will need to report to Mr. McCarron in the district court probation office. That's down on the first floor this coming Tuesday at 8:15 a.m.
Okay, Your Honor.
So that's Tuesday, June 16th at 8:15. Okay, so you are all set for today.
Thank you, Your Honor.
Mr. Murphy, I have Mr. Merritt here. I understand you are representing Mr. Merritt.
Yes, Your Honor, ready to proceed whenever the court's ready.
You're all set. Like I said, just call me just a second. Okay. Make sure we got a good one after the meeting. Thank you. You're up.
Okay, this is file 25-22132-FH and 25-22113-FH. People versus Timothy Joe Merritt Jr. We're here today for a probation violation hearing. We're proceeding today by video conference and in person. Mr. Bennett, are you going to appear on this or?
Yes, Your Honor.
Okay, go ahead. Place your appearance on the record then.
Alex Bayonetta for the people.
Matthew Murphy appearing on behalf of Mr. Merritt.
And sir, you're Timothy Joe Merritt.
Yes, sir.
All right, Mr. Murphy, where do we stand with Mr. Merritt's cases today?
Your Honor, this Bob includes with it an allegation that Mr. Merritt committed a new offense, which the clearing examination for that new offense is scheduled for June 30th. So I was going to ask if we could just set this, if not for July 1st, the day after. Then whatever, if the court schedule best shortly after that, I think that would be the best thing to do in regards to this, Bob, at this time.
Okay, Mr. Bayonetta, anything that you would like to address?
Unless Mr. Murphy has an objection, I think it might make sense to do July 8th instead of the 1st. That way, if Mr. Merritt's case is bound over, it should be in front of Your Honor for arraignment on the 8th.
Yeah, that'll probably make a lot more sense.
Okay. We'll go with July 8th at 8:15 a.m. then.
Thank you.
All right, anything else we need to address with these cases?
Nothing from the defense, Your Honor, at this time. Thank you.
Okay. Mr. Merritt, you can let the officer with you know that you're done with court for today.
Thank you, Mr. Merritt. You have a good day, okay? Talk to you again soon.
I did when I talked to you.
Oh, okay. Well, there's another room. The camera's not on, so let me see if we can. If there is someone in the jail Zoom 1, I just sent a request to start the video in that device.
Thank you, Your Honor. You have a good day.
Thank you, Mr. Murphy. You too.
Go walk over to my office.
Yeah. I call the jail. If he's there, the camera's not on.
I'm meeting you million on the Hi, Captain Judge Sleepers. Do you have Ricky Silva in one of the Zoom rooms? Okay, so the judge says the camera's not on. Okay. I just got done with Merritt, and we could use Emiliano Flores. Great, thank you.
Ms. Underwood, do you need to speak to Mr. Soto? Ms. Underwood, are you there?
Maybe just briefly, Your Honor.
Okay, 1 second.
Good morning, Ms. Underwood.
Mr. Soto, if there's something on your screen asking you to join, go ahead and click join.
Oh, I'm not sure where to put it, Your Honor. Push the television?
Hang on, we'll send someone there to give you some help.
Thank you.
Yep.
Kelly, Judge Sleepers. Mr. Soto is in jail zone 1, and he needs help connecting with the Zoom session, please. Thank you.
All right, and sir, you are Emiliano Flores?
Yes.
Mr. Flores, as soon as Ms. Underwood is done with her current client, I'll have you speak to her. This is file 26-22659-FH. People of the State of Michigan versus Ricky Gomez Soto. We are here today for arraignment. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Sorry, Your Honor. I don't think, I think I was muted. Alex Bayanetto for the people.
Rhonda Underwood for Mr. Soto this morning, Your Honor.
And sir, you are Ricky Gomez Soto.
Yes, Your Honor.
Ms. Underwood, does Mr. Soto wish to have the information read?
We would waive the reading of the information, acknowledge its receipt and the receipt of the witness list and request for discovery, Your Honor. At this time, we would ask the court to enter a not guilty plea for Mr. Soto and set this down for a pretrial, Your Honor. Mr. Soto, Your Honor, has been in jail for a while. He has both physical and mental limitations, Your Honor. If the court would allow him out on a very strict PR, Your Honor, Mr. Soto would live with his sister, Gloria, on Treat Street. Mr. Soto understands at this point, Your Honor, that he cannot, no matter the reason, no matter if they're calling, no matter what, he realizes he cannot visit the alleged victim in this matter at her adult foster care, Your Honor. Mr. Soto understands that now, and his family is going to be instrumental in allowing him a place to live and seeing that he behaves appropriately. We would ask the court to give Mr. Soto PR bond at this point with any conditions the court feels comfortable.
I will enter a not guilty plea for Mr. Soto. We will set this for a pretrial on July 1st at 8:15 a.m. And Mr. Bayanetto, is there anything you'd like to say about the bond modification request?
Yes, Your Honor. Just so this court has a little bit of background in the case, bond was heard for Mr. Soto, I believe, 3 times in district court. Mr. Soto, Your Honor, has an extensive violent criminal history. I count 8 separate domestic violence convictions. The allegations in this case are that he threw multiple things at the listed victim. However, one of the items thrown was a pan that was so mangled from the force that it was thrown that it couldn't sit flat anymore. Your Honor, at the time Mr. Soto was arrested on this case, he had a blood alcohol level of 0.272. So Ms. Underwood keeps making this argument that because Mr. Soto has health concerns, he should not be held in the jail on bond while his case is pending. But the defendant continuously has issues with alcohol. This is dated back months. We just resolved a case with him, I think 4 months ago, where alcohol was the center issue in the case. So the bond ultimately in district court was reduced to a PR bond with an alcohol tether. And Mr. Soto at that time was instructed not to have any contact with the victim. I had voiced my concerns that he was having contact with the victim while we were in district court based on Mr. Soto's knowledge of her movements. That was denied by Mr. Soto. However, after he was ultimately released on that PR bond with a scram unit, he began visiting the listed victim in violation of that no contact order. We have confirmation that he violated that at least 3 different times, and that's from multiple sources from the facility in which the listed victim is living. Further, Your Honor, there were multiple tampers with the scram unit as well as the violations on the no contact order, in which Mr. Soto acknowledged he was putting a sock between the unit and his leg. So, Your Honor, Mr. Soto just seems to be unable to follow any orders from the court. He can say that when he's in front of this court, he'll follow it, but when he gets out, he just simply does not follow through with any of that. At the last court date where the preliminary exam was waived to have this case bound up to circuit court, Judge Morgan again heard bond and reduced it to $5,000 with a GPS tether should the defendant post bond. I think that's absolutely appropriate as it stands, and I would ask that the court not modify bond at this time.
All right, having had a chance to review the file while the attorneys were making their arguments and having heard the arguments that they've made, I don't believe that at this point would be appropriate or wise to modify the bond conditions based on Mr. Soto's past history and performance. Well, on the scram tether, their file does reflect those tampering issues, and so I think the court has tried to show some leniency to Mr. Soto, and that has not gone well when Mr. Soto's had the opportunity to be out. So I think the bond in this case is appropriately set to deny the request to modify that. Mr. Soto, you can let the officer with you know that you're done with court for today.
Yes, Your Honor. May I say something, Your Honor?
Not at this point, Mr. Soto. You are represented by an attorney, and I don't want you to say anything that might compromise your case.
Yes, Your Honor. Will I get a PR bond, please?
No, you're not getting a PR bond today.
All right. When's my next date to court?
I say July 1st. I think I said July 1st at 8:15.
Yes, Your Honor. Yeah, I spoke to Dan.
Okay, I don't want you to say anything about who you spoke to or what was said. It's not appropriate to deal with right now. So just let the officer with you that you're done with court.
Yes, Your Honor.
Ms. Underwood, do you need to speak to Mr. Flores?
Your Honor, could I speak to Ms. Walsh for a second?
Yeah, 1 second. Okay, Ms. Underwood, are you ready to proceed, or do you need to speak to Mr. Flores?
I need to speak to Mr. Flores, Your Honor, who I believe is muted. There.
Before it's cleared. Good morning again, Mr. Amadeo. I did get a complaint for violation of bond conditions. Did that get forwarded to you?
I did. Thank you, Judge.
Okay.
I made crystal clear mechanism. Thank you. Bye. All right, this is file 24-22069-FH People of the State of Michigan versus Leano Julian Flores. We are here today for a hearing on a probation violation, and we're proceeding by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Flores this morning, Your Honor.
And where do we stand with Mr. Flores's case?
I believe Mr. Flores is prepared to take responsibility for his actions, Your Honor, and plead guilty to the violation.
Sir Flores, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
Do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
You understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand
Yes.
all of that?
Yes, sorry.
You do not have to testify at your trial, and no one can say anything about you not testifying or put that against you in any way. Do you understand that?
Yes.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you violated your probation by consuming alcohol on or about May 30, 2026 and blowing a .20 PBT?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained to you?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anybody threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record, or that it was not your own choice to enter that plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
You were placed on probation in this case back
around April 2025. Is that correct?
Yes.
One of the requirements of your probation was that you were not to consume any alcohol. Is that also correct?
Yes.
On May 30, 2026, did you consume alcohol?
Yes.
Did the police come to your home?
Yes.
Did they do a PBT on you?
Yes.
Did you blow .20?
Yes.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Flores has full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation. And we can set sentencing for June 26th at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. Flores, Ms. Walsh will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about what happened and about your background. Okay, so you're all set with court for today, Mr. Flores.
Thank you.
Okay, we are back on the record then in file 26-22649-FH and 26-22650-FH. Versus Crystal and Claire, and we previously had a pretrial hearing at which the pretrial was adjourned to June 24th, I believe it was. Mr. Amadeo, do you want to speak to Ms. Claire?
Briefly, Judge, if I may.
Okay, let me put you in a breakout session.
Thank you.
With her.
Okay, we have Mr. Amadeo and Ms. Claire back from breakout session. I do now have a complaint for violation of bond conditions. Ms. Claire, have you received a copy of that document?
No.
All right, we'll send a copy of it over to the jail so that you have a copy of that. In the meantime, I will let you know that the complaint alleges that you violated your bond conditions by leaving your residence on June 9, 2029, at approximately 3 p.m. That would be considered a violation of your bond conditions. The maximum possible penalty for violating your bond conditions or contempt of court is up to 93 days in jail or up to $7,500 in fines. Mr. Amadeo, you want to place your appearance on the record then?
Thank you, Your Honor. William Amadeo, P7619, on behalf of Crystal Claire. We both consent to Zoom. We'll stand mute right now, Judge. Waive any other formal readings and ask to be heard on bond when appropriate.
All right, I'll enter a not guilty plea for Ms. Claire on that. We will set this for the same date as the pretrial, June 24th, 8:15 a.m. And Mr. Amadeo, what would you like to say about bond?
Well, Judge, I'm fairly certain we will do a global plea on the 24th, which will include this. She did tell probation in juvenile court that she will have a positive test for cocaine from 3 days ago. I'm asking her to be released. She needs treatment. We're going to get this case done. There's clearly a drug problem, Judge. So if you decide to give her any jail time, I ask it to be minimal. She was honest about the positive test. She is guilty of this violation, but the reason I'm standing mute right now is I want to wrap everything into one. I don't want to take the court's time with a hearing, but I am trying to get her help. I ask you to consider those factors. Thank you.
Mr. Van.
Your Honor, I received word, so Ms. Claire's son is currently under the jurisdiction of the probate court. As he's under that jurisdiction, Ms. Claire has been testing through that case. I was made aware this morning from her son's probation officer that throughout the time she's tested, she's consistently tested positive for cocaine. I agree with Mr. Amadeo that she needs help. I have no objection if the court wants to release her to rehab or something that's going to force her to get the help that she needs. But I at least at the very minimum, whatever the court wants to do today, think that the court should add some drug conditions going forward. Drug testing conditions on these cases.
And if I could just briefly reply to that, Judge, I think drug testing is highly appropriate. And Crystal, please do not say anything. Anything can be used against you. Let me do the talking. Thank you.
Okay. As far as a bond in this situation, I do think that a bond is appropriate because we have, in addition to the complaint here, more or less an admission that there's a substance use issue happening. I have no problem releasing people to treatment where they want to have help dealing with that substance use issue. But I can't simply issue PR bond and let a person I know is using substances to walk out the door and do whatever they wish. It is going to be my decision that bond be set in the amount of $15,000 cash security. Ms. Claire can be released from that directly to a residential inpatient treatment facility. And again, we'll set everything for June 24th at 8:15 a.m.
And Judge, if we could also add a no alcohol drug use and also random testing for when she's not in treatment.
Yeah, give me just a second. So obviously those are appropriate conditions. So no use of alcohol, marijuana, or any illegal controlled substance, must participate in a substance abuse testing or monitoring program as directed by Mr. Coast in pretrial services. Along with any other prior conditions that were in place.
And Judge, if I could please get a breakout with Miss Claire, just so I could go over the treatment options with her.
All right, Mr. Amadeo, do you want to be in that breakout as well?
No, thank you, Your Honor.
All right. Ms. Claire, hang on just one second. I'm going to put you in a breakout session with Mr. Coast, and then when you're done with Mr. Coast, you can let the officer with you know that you're done with the court.
Thank you, Judge.
Thanks, Judge.
Your Honor, I think that's my docket with you this morning.
Yes, we are all set.
Okay. Yeah, have a good day.
Thank you. You too.